हेलो गाइस एंड वेलकम बैक टू माय न्यू वीडियो। आज की वीडियो में हम लोग सेक्शन 20 डिस्कस करेंगे एसआरए का, विच इज़ सब्सटीट्यूटेड परफॉर्मेंस ऑफ अ कॉन्ट्रैक्ट। तो चलिए स्टार्ट करते हैं। विदाउट प्रेजुडिस टू द जनरलिटी ऑफ द प्रोविजंस कंटेन्ड इन द इंडियन कॉन्ट्रैक्ट एक्ट एंड एक्सेप्ट एज अदरवाइज अग्रीड बाय द पार्टीज। मतलब ये जो सेक्शन हमारा क्लॉज 1 है उस पर दो कंडीशंस इम्पोज हो रही हैं पहले ही एप्लीकेबिलिटी पर। विदाउट प्रेजुडिस टू द प्रोविजंस कंटेन्ड इन आईसीए, मतलब इस सेक्शन को आईसीए दैट इज इंडियन कॉन्ट्रैक्ट एक्ट से कोई फर्क नहीं पड़ता। एंड ऑल्सो इफ देयर द parties have agreed upon such terms or conditions which are not in consonance with what is mentioned in the contract, so in that case this section won't come into play. So this is the entire genesis of the first sentence, where the contract is broken due to non-performance of promise by any party. That is, there has been a breach of the contract. The party who suffers by such breach shall have, that is, it is mandatory, it will be there in all circumstances, the option of the substituted performance through a third party or by his own agency and recover the expenses and other costs actually incurred, spent, or suffered by him from the party committing some breach. In simple words, say there are two parties X and Y. There are two parties X and Y. They were into a contract for making of, say, food for 50 people for a particular party. X is hosting a birthday party for his brother and he has hired Y to cook food for, say, 50 people. And let's say that the pay decided has been 15,000. Okay. So now what happens is that on the day of the party in the morning, Y says that I will not be able to make food for this many people and it's not possible for me to do this work. I am really sorry. So what happens? The contract has been breached. Now what are the remedies with X? X can very well seek damages from Y. But what help will the damages give? The party is in the evening. So damages might be a good remedy as far as we can say the mental stress was caused to X, but damages won't be an immediate solution, right? So what will X go for? Specific performance. But in this case, what happens? Even if he'll file a suit for same, it will take a lot of time. The party is today. What he does is he instead approaches Z. This fellow Z, he has another restaurant. He approaches Z and says that it's my brother's birthday party and I need to give him surprise and all those kind of things. And Y has broken the contract, so please help me. I need food for 50 people. So this fellow Z says that okay, I'll help you out, but the cost will be 30,000. Reason being, you have made the booking at the very last moment and I'll have to pull some extra strings to make it happen. X agrees. So in this situation, what all has the X faced? X has not only faced mental pressure because of the situation, he also suffered, say, a loss of 15,000 rupees. Why? Because earlier he would have got the same food for 50 people in 15,000 rupees. Now he has got it for 30,000 rupees. So this is a example of substituted for performance of a contract whereby X, the contract between X and Y was breached by Y. So X approached a third party for the performance of the same contract and it was done so rightfully. Now let's say if Z or any other party refused to help out X, then in that case what would have been the remedy? In that case, X might have chosen to make food on his own accord. He might have just bought the stuff, the groceries and all needed, and he must have cooked the food on his own. That costed him, say, 25,000. He had to buy the groceries, he had to get the gas stuff and all those things. So it costed him 25,000. This is an example of on his own agency. He performed the contract on his own. Whatever the contract was envisaged to be done for, the same was done by X only. So this is an example of substituted performance of a contract. Now let's move forward. No substituted performance of contract under subsection 1, that is the previous subsection, shall be undertaken unless the party who suffers such breach has been given a notice in writing of not less than 30 days. So the party in breach calling upon him to perform the contract within such time as specified in the notice, and on his refusal or failure to do so, he may get the same performed by a third party or on his own agency. So in this clause, it is said that substituted performance of a contract can only be undertaken when a notice has been given in writing to the party who has breached the concept in not less than 30 days. So in this example, when Y had breached the contract, and if X wanted a substituted performance of same, he should have given a notice to Y of 30 days that, see, now you have breached the contract. This is the last chance that you have. In 30 days, either fulfill the contract or then I'll get it done elsewhere. So this is kind of a last chance or a warning given to Y to fulfill his obligation and to prevent any other legal action upon him. So that's the genesis of the clause 2. Provided that the party who suffers such breach shall not be entitled to recover the expenses and costs under subsec 1 unless he has got the contract performed through a third party or on his own agency. See, clearly X has been at a loss in both these cases. Has in the case where the work has been done by Z, or in the case where X has himself done the work. But this loss has occurred when? The loss has actually occurred when he has got that work done, when the performance of the contract has been done by the third party or on his own accord on his own mutual agency. If he had not got the contract performed by any third party, there would not have been any monetary loss as such, the amount of 15,000 or the amount of 10,000 as in this example. So what this subsection means to say is that the party who has sought the substituted performance cannot seek the loss he has suffered from Y until and unless such loss has been actually incurred by him in performance of the contract by the third party or on his own agency. So I hope that this has become clear. I will be repeating it once again. If the contract has been performed by the third party or by the person who has suffered himself, only in such a case can he or she seek the extra expenses, all the loss incurred by him from the party who originally breached the contract. Now let's move forward. Where the party suffering breach of contract has got the contract performed through a third party or on his own agency after giving notice under subsection 1, he shall not be entitled to claims relief of specific performance under the party in breach. This is quite simple and already discussed in my previous videos, and I have also mentioned it here already, section 14 and 16. That once a substituted performance of a contract has been obtained, then the specific performance of the same cannot be sought from the party who had breached the contract originally, which is practical and also quite reasonable. Why would you want a contract to be performed twice? You wanted a certain thing to be done, you got it done already. Now the remedy you have against Y is you can seek the expenses, extra expenses, etc. which you incurred because of the substituted performance. You can also seek damages because you had faced a lot of hassle and all those kind of things. But specific performance is a big no. It's not practical and it's also not equitable. Clause 4. Nothing in this section shall prevent the party who has suffered breach of contract from claiming compensation from the party in breach. As I already stated, though he cannot get specific performance of the contract enforced, but he can very well claim compensation or damages for the reasons I mentioned just before. So I hope that all of you have liked my video and you will forward it and make your friends watch it, and I hope that this video does well. Thank you so much.